Recognising and respecting Indigenous cultural and intellectual property rights is a fundamental step in the process of self-determination. Self-determination is the language First Nations peoples use to describe the path along which Australia should proceed in respecting Indigenous laws and ways of being. Cultural information has been passed down in First Nations communities through paintings, songs, dances, and stories. Terry Janke, an Indigenous scholar, writes about the deep injustices that have seen the commercial exploitation of these works appropriated without the consent or knowledge of Indigenous peoples. This video will focus on copyright protection and discuss some of the issues Aboriginal and Torres Strait Islander peoples have in regards to the reproduction of their artwork. The first problem is that traditional stories will not be granted copyright protection as an original work. This is because creation stories and Indigenous knowledge was traditionally passed down orally. However, under Section 22(1) of the Copyright Act, 1968, copyright can only exist if the work is in a material form. These stories are also likely to have an unidentifiable author, and even if the author was identifiable, copyright in works only operates for the life of the author plus 70 years. Therefore, the term of copyright will have already elapsed, and the oral information would now be regarded as falling within the public domain. A second problem is that copyright owners do not have to adhere to customary Indigenous laws. This has been a discussion of debate for the courts when dealing with Indigenous artworks. In Yambulal and the Reserve Bank of Australia, an Indigenous artist, Terry Yambulal, brought an action against the Reserve Bank and the Aboriginal Artists Agency for the reproduction of his artwork, the Morning Star Pole, on the $10 bicentennial banknote. Justice French found on the balance of probabilities that at the time the exclusive licence was granted to Aboriginal Artists Agency Limited, Yambulal knew that the Reserve Bank was interested in including the particular work on a banknote. The infringement of copyright was settled by consent. However, Yambulal was still subject to considerable criticism from the community for allowing the Morning Star Pole to be used on the banknote. This case highlighted the fact that an author of Indigenous artwork has the power to make decisions for their vested interest and not the interests of the community. The third issue is that IP law fails to recognise authorship of work as a collaborative endeavour. The notion of recognising collaborative endeavours was raised in the case of Boolan Boolan and RNT Textiles Proprietary Limited. Mr. Boolan Boolan used communally owned designs and knowledge in a painting which he created with permission and in accordance with customary law. RNT Textiles was found importing a fabric from Indonesia with a slightly modified version of the painting. Mr. Boolan Boolan successfully argued that his copyright had been infringed and was awarded damages. However, at page 263, Justice Von Dowses stated that equity would impose on Mr. Boolan Boolan obligations as a fiduciary not to exploit the artistic work in a way that is contrary to the laws and customs of the Galangbingu people, and, in the event of infringement by a third party, to take reasonable and appropriate action to restrain and remedy infringement of the copyright in the artistic work. In conclusion, Aboriginal and Torres Strait Islander people found it difficult, firstly, to gain copyright protection over traditionally verbal information, secondly, to ensure the author of Indigenous artwork considers customary laws when distributing their work, and thirdly, to ensure collaborative artistic endeavours are legally recognised. However, the case of Boolan Boolan shows that the courts are now taking Indigenous peoples' customary laws into consideration.